Um, the bailiff has informed me that the jury has not, and they have reached a verdict in this matter. Have you talked to them about making sure the form was filled out, telling them to keep it in the envelope?
I did advise her to put the form in the envelope. I did not ask if it was completely filled out.
I'll go through all that with her. I assume that she did that. Madam Court Reporter, the jury foreperson is number 8, and I can provide her name for you later.
I see right on the list.
All right. So I'll address my comments to her. If you'll bring in the jury, please.
Yes, sir.
And while he's doing that, I'll just remind those that are in the courtroom to remember to conduct themselves appropriately. And I only say that because there was somebody who I have no idea was made some comment the other day.
Your Honor, do they need to bring their notebooks and stuff with them?
No, they can leave that, and I'll let them go get all that later.
They're using the restroom here.
All right. All right. Let the record reflect that all 12 members of the jury are present in the courtroom. The bailiff has informed me that you folks have knocked and have informed him that you've reached a verdict in this case, and I need to ask the foreperson, and I'm not going to state your name on the record at this time, but I'm going to ask the foreperson some questions about that. And first, has the jury in fact reached a verdict in this case?
We have, Your Honor.
And have you indicated on the verdict form what that verdict is?
Yes, we have.
And the verdict of the jury, is it a verdict that all 12 of you have agreed to?
Yes, Your Honor, we have.
And have you signed and dated the verdict form?
Yes, I have.
And I guess indicated or marked the form in an appropriate manner so that it will reflect what your verdict is?
Yes, sir, we have.
All right. And is it in the envelope that you have?
Yes.
All right. If you would hand that to Mr. Carroll, please. All right. At this time, I'm going to ask the clerk to announce the verdict of the jury, please.
Yes, sir. Ladies and gentlemen of the jury, your foreperson has returned a verdict in file number 13 CRS 2252, the state of North Carolina versus Markeith Council. We, the jury, by unanimous verdict, find the defendant, Markeith Council, to be guilty of involuntary manslaughter. This is the 12th day of December 2013. Is this your verdict? So say you all.
Yes.
Members of the jury, if this is your verdict, if you would please raise your hand to indicate or signify that. All right. Let the record reflect. I see all 12 members of the jury have raised their hand. At this time, is there anything else for the jury from the state?
No, sir, Your Honor.
Anything else for the jury at this time from the defense?
Your Honor, we would accept the jury.
All right. Members of the jury, let me explain to you what's going to happen here in just a moment. First, I'm going to ask that all recording devices be turned off in the courtroom because we are going to poll the jury and, or at least anything recording your voices. They're not allowed to photograph you. But what will happen is the clerk is going to start with the foreperson and she'll ask you to stand and she'll ask you some questions, and they're yes or no questions, and if you would answer them as you deem appropriate. When she finishes with the foreperson, she will then go to each juror, starting with juror number 1 and go through 7, and then obviously skip the foreperson and then pick up at number 9 through 12. And she will ask a series of questions to each of you individually. And at this time, I'm going to ask the clerk to poll the jury.
Carol Hessenfluh, please stand. Carol Hessenfluh. You have returned a verdict of guilty of involuntary manslaughter. Is this your verdict?
Yes.
Do you still assent thereto?
Yes.
Thank you, sir. Have a
At this time. Members of the jury, I'm going to accept your verdict in order that it be recorded and made part of the record. Mr. Willoughby, is the state at this time prepared to pray judgment?
Yes, sir, we are, Your Honor.
All right.
Realize this document, who's standing out there, desire to be.
All right. Mr. James, is the defense ready for sentencing at this time? Yes, sir. All right. Mr. Willoughby, do you wish to be heard on behalf of the state? On sentencing?
Yes, sir, I would ask that Ms. Gilbert be allowed to speak on behalf of the family, Your Honor. Do you choose to do that now, or do you want to do it?
Let me hear from her after I hear from
Okay.
you and Mr. James.
Well, Your Honor, this is, as I said to the jury, this is a very sad case. It's a case where someone didn't need to die. The force that was used was, I believe, clearly excessive. I think what happened in the jail was both legally and morally wrong, and I think that the jury has spoken and they have decided as to what laws of our society that this conduct violated, and I support their decision. But I do believe it's a Class F felony. I prepared a worksheet that it's a level 1. To my knowledge, there's no prior conviction of any sort that would move out of level 1. But, you know, I do believe that this is the taking of someone's life under these circumstances is a very serious matter, different from the taking of a life through a motor vehicle accident in which it's simply negligence. I think that this did show that there was the intent to do something that you were not allowed to do, that there was some assault that was unpermissible, and I think that some type of sentence that involves some active portion of imprisonment is appropriate in the case for the taking of someone's life, and I would ask Your Honor to consider that and exercise your discretion. You've heard the evidence, you've seen cases over the years, but this is a very, very serious matter, and I think we cannot lose sight of the fact that the actions of this person took someone's life needlessly.
Thank you, sir. Mr. James.
Yes, Your Honor. I had the opportunity through the course of this matter to learn quite a bit about my client. Learned that he's a 27-year-old man, his father, 3, his wife is pregnant with the 4th child. You learn that he went through high school, Your Honor, was good enough in football that he earned a scholarship, went to college, earned a 4-year degree as an athlete. With the dream, he earned that degree in criminal justice. He said he always had the aspirations of becoming a warden in the detention arena. He said he was on track. He wanted to become sergeant within 5 years and master detention officer. He's been married for 2 years, Your Honor. His wife is a law enforcement officer with Lawler PD. no prior criminal history, Your Honor. It is a class F felony, so the court does have some discretion. I would ask the court in its discretion as it considers what it is about to do, consider some mitigating factors. We would ask the court in its discretion to consider mitigating factor number 12, which states that the defendant has been a person of good character or has had a good reputation in the community and lived. The defendant has served as a detention officer for more than 4 years. We know that the county sheriff's department is a very close look at the individuals that they employ and remain employed with. We would also ask the court to consider mitigating factor number 17, defendant supports defendant's family. We also ask the court to consider mitigating factor number 18, that the defendant has a support system in the community as we perceive the defendant's view. His mother, his wife, another young lady here that has known through high school, she on his behalf, as well as cousin from his hometown. The defendant has had a positive employment history or was gainfully employed, mitigating factor number 19. From the time he graduated from college, he was able to get on with the county sheriff's department. He has maintained that employment since that time, up to the time when these charges were brought against him. Your Honor, at the class level, Class F, level 1, of course, we would ask for these consideration to consider mitigating factors. These mitigating factors will find that they outweigh any aggravating factors, and that no aggravating factors exist that have been presented to the court. Minimum sentencing at the aggravated range, the mitigated range, Your Honor, is 10 months. And that carries a 10-month minimum to a 21-month maximum. We would ask the court in its discretion. We believe, Your Honor, that we would ask the court in its discretion to suspend that sentence, place him on supervised probation, and allow him to serve that sentence through probation. Otherwise, Your Honor, the court is inclined to give him an active sentence as requested by the state. We would ask the court if it would consider a split sentence rather than a straight active sentence. His wife is pregnant again, expecting a fourth child. She's approximately 5 months pregnant. Then we would also ask, Your Honor, if you would to allow someone to speak on his behalf. The young lady that I spoke about that was known him all the way through high school.
I will. I want to hear from Mr. McLean's sister too, but I'll hear from your witness at this point, and then I'll hear from Ms. McLean, or Mr. McLean's sister. Yes, ma'am. If you would state your name for the record, please.
My name is Georgiana Kaczynski, K-I-C-I-N-S-K-I.
Yes, ma'am.
Well, I have been a friend and watched Markeith counsel grow since he was in high school and played football with my son. I watched him all through college, stayed in touch with him, been at my bedside for a couple of surgeries. He has got a beautiful heart, and I don't believe personally that there ever was any intent. This man does not have emotion on his mind. He's got more faith than I've ever seen in my life. And I really hope you will take all this into consideration, because this is not an angry man. This is not a man who has anger issues. He's always been a kind-hearted soul. People have wronged him in high school, and he was just introverted to himself. He never flared out. He never acted out. And I've known him since 1982. And I hope that you will consider this. This is not a man who goes around and has a violent temper. He doesn't. This was a terrible accident. And I can't say any more to it. But please consider the fact that he's a good man. He's a good son. He's been like a son to me my whole life. And I hope that you will consider all these things when just determining his sentence.
Thank you, ma'am.
Thank you.
Would you also hear from his wife?
Yes. Yes, ma'am. If you would state your name for the record, please.
My name is Antoinette Bell, counselor. I am the wife of Markeith, counselor. Your Honor, I pray that you show mercy towards my husband. He's been a loving husband, an outstanding father to our children. It is my daughter's birthday, and I promise that we will all be home to take her out. And I just pray that you give me a mercy.
Yes, sir.
The last thing we'd like to say to the court, Your Honor, on behalf of our client here as we just to extend an apology and say to the family of Mr. McClain, we're very sorry, very emotional for what happened. Sorry that he lost his life. We're sorry to them for the loss of their loved one. And so, Your Honor, we would ask the court for discretion to take the things into consideration that it's heard and place it in consideration.
All right. Mr. Willoughby, did you have additional folks that wanted to be heard on behalf of Mr. McClain?
Only on Ms. Gilbert, Your Honor.
Yes, and
You are sure it's not perfect. We all know that. But he's still my brother. I love him and I miss him. None of us is perfect. But the problem I have is Ms. Counsel never once showed me this. He thought it was his job to do that. My brother has 2 kids. He's a loving father. He has a daughter that misses him. She's turned 16 a week after his death. He died a day after Father's Day because I refused to pull the plug on Father's Day because I don't want her to have that in his mind. Her father died on Father's Day. She missed him dearly. She missed what he did. She made a post on Facebook. The new one. Daddy made it easy or something. But she missed him. I miss him. He has family, friends, all miss him. And I'm going to ask you to give him the next because I think that he deserves the next. Because if every officer would take it upon themselves, if just somebody run off the notch on this level, we'd be in court. Someone would be in court every week for this. So I'm just asking you.
anything else, Mr. Willoughby?
No, sir, Your Honor.
Or Mr. James? All right. Will the defendant please stand? The jury has returned a verdict of guilty to the Class F felony of involuntary manslaughter. The court finds there are no prior record level points and that the judgment is a level 1 for felony sentencing purposes. I have considered this, all the evidence that I've heard throughout the entire trial, the statements of the witnesses, the arguments of counsel, the statements of the folks that have come forward today to speak on behalf of Mr. McClain as well as Mr. Counsel, and I'm going to enter a judgment that I believe is the appropriate judgment. I know no matter what I do in this case, people are not going to like it, and that's just where the chips fall, and it's my responsibility to enter a judgment that I believe is the appropriate under the law and the facts and in the best interest of justice. The judgment of the court is going to be a mitigated judgment. I do find mitigating factors 12, 17, 18, and 19, specifically that he does have a reputation for good character in the community prior to this incident, and that he supports his family, he has a support system in the community, and that he has a positive work history. This is a Class F Level 1 mitigated range judgment. The judgment of the court is that the defendant be imprisoned in the Wake County Jail and assigned to the North Carolina Division of Adult Corrections for a 12-month minimum to 24-month maximum. Without his consent, that sentence is suspended, and he is placed on supervised probation for a period of 36 months. He is ordered to serve an active term of 90 days in the Wake County Jail, which will begin today. I heard what your wife said about your daughter, and I considered that, but I consider that Mr. McLean will never spend another day with his daughter, let alone a birthday, and you have other children on the way that you need to be prepared to tend to. I'm not doing a delayed commitment. The normal terms of probation will apply. The defendant's required to provide a DNA sample for the DNA database. He's ordered to pay the cost. He's ordered to pay a fine in the amount of $1,000. He's ordered to abide by all the other normal terms and conditions of supervised probation. And because it's less than 120 days, I believe it's appropriate that he's ordered to serve that time in the Wake County Jail. Was there anything else on behalf of the state?
Yes, sir.
Or the defense? All right. He is in custody of the sheriff, and I need to, at this time, thank the jurors and formally discharge you from your service in this matter. Being called for jury duty is no easy task for any kind of case when we ask you to interrupt your busy lives, particularly this time of year. But cases of this type, of this emotional impact, are difficult, and we appreciate the fact that you have participated. You've been here when we've asked you to be here. You have stayed focused. You have been attentive to all the evidence that we have offered to you, and we appreciate your service. You will no longer be subject to the rules that I have given to you, and we're going to ask for that red badge back so we can recycle it for next week. I'm going to ask you to go through your notebooks, and I think they're still in the jury room, and ask you to tear out any notes that you don't want us to see and destroy those. If you want to leave them, that's fine. We'll take care of all that ourselves. If you want to, well, the rules don't apply anymore, so if you want to talk about the case, you can talk about the case if you want to. Some people find talking through things such as what you've just been through to be helpful, but everybody's different. I'll leave that up to you. If you don't want to talk about this case, you don't have to talk about it. I can tell you that oftentimes lawyers like to talk to jurors after a case so that they can get a feel for whatever it is that you did or they did, what they did or didn't do, or that you liked or didn't like, that will, they'll build on that for the next trial. They're not trying to impeach your verdict or be critical of what you did, but they like to get feedback. As I said, you don't have to talk about the case if you don't want to. If you don't talk about, if you do talk about the case, just remember to only say those things that you would be comfortable saying in front of other people in an open forum such as a public courtroom like this. But what I mean by that is, in the jury room, oftentimes people say things or stake themselves out to a position that they would just as soon remain private between the other members of the jury. But please keep that in mind. And like I say, if you don't want to talk about it, you don't have to. You have the absolute right to be left alone. You're going to receive a check from the clerk in a few weeks, which is in no way a measure of the value of the services that you have provided in this case. It is a small per diem amount that will hopefully offset any incidental expenses that you may have incurred coming along the way, for gas, lunch, whatever the case may be. That's all that I have from you other than a final thank you. I'm going to ask you to go with the sheriff. He's going to collect those red badges from you, and we'll get your notebooks, and they'll also see to it that you are safely out of the building and on your way. And, thank you all very much. I'm going to ask everyone else to please remain seated while the jury is excused.
Let the record reflect that all members of the jury have left the court. Anything else from the state?
No, sir, Your Honor.
Or the defense?
No, Your
All right, very well. Do I? Oh, I'm not. And Sergeant, we're adjourned till tomorrow morning at 9:30.